go into a suicidal episode. We are coming off of 2 years of, he had 3 suicidal attempts, which put him all the way to life support, months of treatment. And then he had neurosurgery to remove a mass in February last year, and then was hospitalized again in March. And I was just starting to rebuild, and then I got really sick this February, and I've basically, I have he's just
Ms.
about to
McFarland?
go back to, yes, sorry.
All right. No, it's okay. It's all right. Here's what I'm going to do. If you want to seek the assistance of counsel, you can. I know that the University of Michigan used to also have a clinic that operated with veterans. So, and let me give you that number. Can I?
I was at the VA yesterday, and I'm working with a social worker, and they've got me set up with a plan and legal help through there.
Okay, so if that doesn't work, there's a number of 763-4319. Okay. And they also have that. Okay, so here's what I'm going to do. I'm going to give you an opportunity to speak to a lawyer, get that information to us. I'm going to adjourn this out to August 21st, 2026, time
12 noon.
at 12 noon. That's an in-person hearing. So everybody would need to be down at the courthouse, and then we'll figure out where we're going to go from there. Okay?
Okay, thank you, sir.
All right, thank you. Nick Hopwood versus Jason Haas.
Good morning, Your Honor. Jean Stewart appearing on behalf of Nick Hopwood.
All right. Jason Haas.
Yes, Your Honor. Good morning.
Good morning. There you are. Okay. It's a non-payment of rent case. What is the plaintiff's claim? How much is owing?
There's $3,300 in unpaid rent currently, and $139.60 in costs, for a total of $3,439.60.
Okay. Mr. Haas, how are you intending on getting that paid?
I have been communicating with Nick, my landlord, throughout the entire time. I had just been laid off from my job at a lab in Ann Arbor, and I was just waiting until I had gotten a new position, which I have. Nick did tell me that I can have some grace during that time. I had also filed for a state of emergency relief, and they just verified my new employer yesterday. And it's for the full amount owed.
Okay, so you filed for an SER?
Yes, and I have the tracking number.
Okay, look in your packet that you received. There's a rental assistance form. You'll need to fill that out. Particularly, you'll need to put the tracking number for the SER
Understood.
on the form. You need to file that with the court by Wednesday.
Okay.
I will then adjourn this matter out to August 21st, 2026 at 12 noon. That's an in-person hearing. You'll need to come down to the courthouse. Just so you know, sir, how many people are in your unit?
It's just me and my daughter. I'm her only living parent.
Say that again.
It's just me and my daughter. I am her only
Okay,
living
there are
parent.
2 people in your unit.
Yes.
So just so that you're aware, if you were granted an SCR, the maximum benefit on that's going to be about $520. Okay?
Yep.
Okay. All right, very good. We'll see you next week.
All right, thank you.
Your Honor, Your Honor, am I still able to submit for the court's consideration a request for attendance at that next hearing via Zoom? I'm not asking Your Honor to
You can submit it. You can submit it. We'll take a look at it.
Thank you very much, Your Honor.
Thank you. Fannie Mae versus Nelson Garcia.
Ready, Your Honor.
Not chips.
I think I have. All right, counsel, state your appearance, please.
Good morning. For the record, Hillary Georgia appearing in place of the Trott Law Firm for the plaintiff Fannie Mae, aka Federal National Mortgage Association.
All right. Nelson Garcia. Don't have them. Did you pay for a second service? I think you did.
Yes, we did.
All right, raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give before the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
All right, go ahead. What is your claim?
Your Honor, at this point, I would ask the court to enter a default judgment in this matter. This was filed as an eviction action pursuant to a sheriff's deed. This is a holdover tenant after a mortgage foreclosure. Service was properly made in this case. We did also seek that enhanced mailing. So I believe that the case is ripe for a default judgment to enter. I apologize, Your Honor. I haven't practiced in front of you before. Do you prefer that those are uploaded through an e-filing system, or how would you prefer that we provide a proposed judgment for the court?
The judgment?
Yes.
And yeah, email it to my staff, Ms. Weidling.
Okay.
And if you don't have her email, she'll put it in the chat.
Okay.
Judgment to the plaintiff, that is by default for possession. No redemption amount, writ to issue in 10 days.
Thank you, Your Honor.
Thank you. Secretary of Housing and Urban Development versus Michael Courier and all other occupants.
Ready on that one as well, Your Honor.
Good morning, Your Honor. Jeff Hall on behalf of Michael Courier. Mr. Courier, can you unmute yourself and state your name for the record?
Michael Courier.
All right. Good morning, Mr. Hall.
Good morning.
All right. This is a termination case, and I'm assuming we're in the same type of position. Is that correct? This is a forfeiture.
That's correct, Your Honor. For the record, again, Hillary Georgia in place of the Trott Law Firm on behalf of Plaintiff Secretary of Housing and Urban Development. This matter was filed to recover possession following a sheriff's deed. It is the same situation after a foreclosure. I apologize. I didn't realize there was an attorney on the other side, or I would have attempted to contact him prior to the hearing.
No, that's okay.
Yes, Your Honor. I reached out yesterday to the attorney of record and got out of office, and then my office called theirs, and we were put in touch with someone else. I asked for a 30-day adjournment to allow for an opportunity to discuss resolution. I think resolution is possible. Got a reply that their client would not allow an adjournment, so I'm nevertheless asking for a 30-day adjournment to allow for a discussion of a resolution.
All right. Well, I don't know that I have authority, at least at this juncture, to grant you the 30-day. That might be a wise thing to do, but I can't. I don't think I can do it. So what I will do is I'll adjourn it to next week, August 21st, 2026 at 12 noon. That is an in-person hearing, and then we will see what the positions of the parties are, and then I'll figure out where we're going to go from there.
Sounds good.
That was
All right.
August 21st, Your Honor?
Yes, ma'am.
Okay, thank you very much.
Thank you.
Thank you.
Good seeing you, Your Honor.
And you too, sir. Arbor Meadows versus Brian Coles. And
Good morning, Your Honor. Good morning, Your Honor. John Capitan appearing on behalf of Arbor Meadows.
Ms. Coles, you're trying to unmute. I see you.
Hi, Catherine Coles.
All right. Thank you, ma'am. All right. This is a termination of tenancy action. Basis for termination is counsel.
Failure to remove properly and store all items. First of all, this is a manufactured home in a manufactured home community. Failure to remove and properly store all items in the shed or in the home. Failure to remove excessive amount of improperly stored items behind the shed and around the deck. Maintain general clean appearance of the home and home site.
All right. Ms. Coles, what's your position on this?
This matter had been taken care of. The manager here is known to target people. I literally have pictures of other places that have items stored behind their shed. We've had these items for a year and a half, maybe, behind there. It was never a problem until she was trying to sell the home next door and couldn't.
Okay, here's what I'm going to do. Are you going to seek an attorney on this, ma'am?
If we have to, we will, yes.
All right, I'm going to give you an opportunity to do that if you think that you should. Obviously, they're proceeding with their position. I will adjourn this matter out to August 21st, 2026 at 12 noon, correct? 3 p.m., excuse me. At 3 p.m. That's an in-person hearing, so you'll need to come down to the courthouse and then we'll figure out where we're going to proceed.
Okay, and what was the date? I'm sorry.
It's 1 week from today at 3 p.m., so the 21st.
Okay, thank you.
Thank you. Arbor Meadows versus Eric Herrera.
And again, John Capitan appearing on behalf of the plaintiff.
Not checked in. Herrera. They are not checked in. If you'd like to take a default, I see the second mailing. If you'd like to take a default, please raise your right hand. Do you solemnly swear for testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. All right.
Go ahead.
This is a termination case. The reason for the request for the termination judgment is that the defendant has failed to maintain their home and home site in accordance with the community rules and regulations, specifically paragraphs 4, 13, and 17 of the lease. In particular, they failed to repair or replace their skirting on the manufactured home, failed to remove improperly stored items, and failed to confirm the occupants of the household. There's been numerous violations with respect to that and no cures to those. Accordingly, we ask for the court to issue a default judgment of possession with the defendant to be vacate on or before August 24th, or a writ may issue.
All right. Judgment to the plaintiff. That is by default for possession. No redemption amount. Writ to issue in 10 days.
All right. Thank you.
Arbor Meadows versus Hilda Hintz Estrada and Kayla Venezuela.
We're here, Your Honor.
And
Okay.
John Capitan for
As
the
I
record.
struggle with the names, right? All right.
You did fine.
Okay. This is a termination case. What's the basis for the termination?
All right, Your Honor, it's a failure to abide by the community rules regulations, specifically failing to maintain that home and home site in accordance with the community rules and regulations, specifically failure to repair skirting, remove improperly stored items, repair a huge swath of lawn. I actually looked at the pictures. Failure to maintain the general clean appearance of the home and home site. There's been a number of violations.
All right. And ladies, what is your position on this?
When we received the notice from them that they wanted us out, I went to the office and told them that we were leaving, that we didn't need to come to the court, but the manager was so adamant on coming to court anyways. So we're already moved into another place. We're just trying to sell the trailer, so that's what we need time for. But other than that, we're already out.
You moved and the trailer is still there.
Yeah, we need somebody to sell it, to move it. Like, we need to sell it.
Okay.
So we've had people come in for an application, but again, the manager has told them that we have to like go in there and let them know that we're leaving. So like, it's kind of been like a little circle.
Right.
They've been,
Okay, so here's what I'm going to suggest you do. I'm going to suggest that in the week adjournment that I give you, that you contact counsel's office, figure out exactly what you have to do regarding the sale of the trailer, and then we'll try to figure out how to get this case resolved. Okay?
Okay.
I'll adjourn this matter out to August 21st, 2026 at at 3 p.m. That's an in-person hearing, so you'll need to come down to the courthouse, okay?
Your Honor, would we have to have it like sold by then?
No, I'm not saying that. I'm just
Okay.
saying the process for the sale of the trailer. You need to make sure that you're following the proper steps to try to get that done.
Okay. I understand.
Okay, and so just contact plaintiff's counsel's office and see exactly where you're going to go and what they need from you.
Okay.
All right.
Thank you.
All right. Thank you.
All right, thank you, Your Honor. That's it for me. Have a great weekend.
You do the same, sir. Pines of Clover Lane versus Kai Berg.
Good morning, Your Honor. Brent Tinger for plaintiff.
Kai Berg, they are not checked in. You have a second mailing. If you'd like to take default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead, sir.
Thank you, Judge. At this time, we would move for a default possession only judgment. The rent to retain is $3,228.47. There is court cost owed of $175 for a redemptive total of $3,403.47. This would have a pay or vacate date of August 24th, 2026.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you, Judge.
Celine Trails versus Kenneth Swine.
Brent Tinger for plaintiff.
Kenneth Swine, not checked in. You've been sworn. You may proceed.
Thank you, Judge. At this time, we would ask for a default possession only judgment. The outstanding rent to retain is $1,195.74. There is court cost of $193 for a redemptive total of $1,388.74. Written 10 days, and we'll submit an order.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested. Writ issue in 10 days. I think that's it. So,
have a good weekend, Your Honor.
You do the same, sir. Huron Vista versus Sabrina Jackson.
May it please the Honorable Court, Steve Gann for the plaintiff. And you thought you're going to have a good day.
She's here. Okay. I'm glad. Miss Jackson?
Yes, I'm here.
Okay, there you are. All right. What is plaintiff's claim?
Your Honor, the current balance is $6,716.40 plus court fees. I do not have the service process fee back from the bailiff, but I assume it's going to be $35 because it always is. So that would give us $225 for court fees.
All right. What's that total? I'm sorry, sir.
I'm sorry. Let me grab a calculator here because I went to public school. Okay.
Wow.
I'm not a terrapin. The total amount is $6,941.40.
Thank you. All right. And ma'am, how are you intending on getting this paid?
Selling in Oregon if anyone is interested. I'm
Pardon?
kidding. No, I am currently,
Okay.
I have a spare car. I have a spare car. I let a friend use it. It's in Ohio right now. She's bringing it back today. I'm going to sell my spare car and do a title loan on my current car, as well as I start school at the end of the month. So I was planning on using my financial aid check to recover the rest of the balance, as well as coming for September rent. The reason it's so far behind and it's been so backed up, I was a flight attendant with Spirit Airlines. So when they went out of business on May 2nd, I went out of business, and my extra job was a substitute teacher. So that was around summertime as well. So I want nothing more than to pay my rent. I want nothing more than to
I got you. It's okay.
Yeah, I'm sorry. That's just such an icky feeling.
I got you. All right. So here's what I'm going to do. I'm going to adjourn this to August 21st, 2026 at 3 p.m. and allow you to try to get some of that potentially resolved regarding the vehicles. And you said you're in school?
Yes, sir. I just got accepted into Eastern the beginning of July. I start classes on the 31st. I have about 3 solid semesters left until I graduate. So I'm trying to walk that down.
All right. What are you going to be when you grow up?
I'm so glad you asked because I was recently inspired. No, but really, I just declared my minor in political science. So ultimately, I want to be a social justice attorney. So I hope this is my last time in this kind of courtroom, but I would be a lot more in the future.
You want to be an attorney?
So bad. So bad. And Judge Simpson, you've had a lot of inspiration with that. You are knowledgeable, you are wise, and you are fair. And yeah, you've had a lot of inspiration with that.
Thank you for saying all of that. Gan, she wins. No, I'm just
understood, Jan, but I thought
See, I wanted you to talk for, I didn't want you to think that's why I said that. No, that's not why I said that at all.
No,
that's just the honest truth.
All right. Thank you, ma'am. We'll see you next week at 3 p.m., okay?
3 p.m. Got it.
3 p.m. on the 21st. Thank you.
21st. Awesome. Thank you so much.
Huron Vista versus Latanya Barney.
May it please the court, Steve Gann for the plaintiff.
Barney?
Good morning, Judge.
Oh, where is she? She didn't
Right
light
here.
up.
Good morning. Good morning.
Oh, there you are. Okay. Your screen didn't light up for me, so I didn't know.
I'm sorry.
All right. What is the claim in this case?
Your Honor, the current balance is $1,256.12.00. Court cost of $220.12. That's $220.12 for a total of $1,476.12. $1,476.12.
All right. Thank you. And Ms. Barney, how are you intending on getting that paid?
Actually, Judge, I got assistance with someone with the organization to pay that amount. It was a $1,305 or $1,325 or something. So that is the incorrect balance owed. I only owe $685 as of current.
So you're claiming you don't owe this?
That's exactly what I'm claiming. As of right now, because I made a $600 payment on last Friday.
Okay.
And
so they made hang on. Do you see that, Mr. Gann?
I do not, Your Honor. They printed this ledger in preparation day on August 9th, and nothing had been entered out as of August 9th. If there's 600, my client, of course, will get that put in. She should check with the manager to make sure that, was it in the Dropbox or was it handed to the manager?
It was in the Dropbox, and the resident portal, it reads, and I quote, 600.
Okay. All right, Miss Barney. Okay. Miss Barney, I get it. It just hasn't been applied to the account. All right.
Okay.
So if it hasn't been applied, all Mr. Gann is trying to tell you to do is to just check with the manager, make sure it's applied to the account. Okay. He has a number for a different time. So you may not owe this much, but whatever. But you don't owe the amount that you may see in the portal will not include court costs. So those court costs are going to be added on.
May I say something? I spoke with the property manager, Sheena McNickens, on last Thursday, and was told that, because it had gone out, but the amount hadn't been applied, that I wouldn't owe court costs or anything like that because the amount had gone down from what it was.
Well, I don't know anything about that. They'd be entitled to court costs because of the filing, but I don't know if there's some other agreement or whatever, and I'll have to.
There's no agreement.
So what is the
we will
court
not
cost?
be waiving the court. The court costs, ma'am, are $220.12. 220.12.
That's
what I
unclear,
will do. What I'm going to do. What I'm going to do is I'm going to adjourn this to August 21st, 2026 at 3 p.m. That's an in-person hearing. Ma'am, you'll need to come down to the courthouse. If there's somebody, I thought you said at the beginning there was an agency or somebody helping you. If there is, the rental assistance form that is in your packet, you'll need to fill that out and submit it to the court by Wednesday. All right.
Okay.
Thank-
What if
Thank you.
it's already been paid? It's already been paid. Is what I'm saying.
What has,
The amount that I'm being sued for has already been paid. It's already been paid.
ma'am. You paid
Yes, sir.
$600, correct?
600 for August rent. The rent that was past due has already been paid, is what I'm trying to tell you, sir.
Their records don't show that. If you have proof of that, I suggest that you take it into the manager, show that it's been paid, and then they'll dismiss the case out. But I don't see that. They don't
Okay,
see
I would go over there right now because like I said, I spoke with her personally.
Here
Thank
on
you.
Vista versus Jeremy Kelly.
May it please the court, Steve Gann for the plaintiff.
How you doing, Your Honor? I'm here.
Okay, doing well. Thank you, Mr. Kelly. And what is the claim in this case?
Your Honor, the balance currently is $5,102.12. That's 5102.12. Court fees of $240.12, $240.12. Actually, the 5102 was the total amount with court fees. The rent portion is 4,862.
Got it. Okay. All right, Mr. Kelly, how are you intending on getting this paid?
Yeah, I've already applied for rent relief. I just haven't heard back from them yet. But basically, like, I was working at Bell Tire, and I went from like 45 hours a week down to like 18 because they were trying to cut my position away because they got bought out by a bigger company. So it really put me in a hole. And then plus my son had an episode of seizures and he had medical bills that my insurance wasn't covering, and neither was his mother's. So I got caught paying for like medicine that he needs. So it just really set me back.
Okay. I got that. You said you applied
Yes.
for assistance?
Yes, I did.
Is that through SER?
I went into the office and they had a placard for, I think it's ESU rent relief. And I just applied through that.
Okay. I'm not sure what that is. All right. So, sir, what I'm going to first thing I'm going to suggest that you do, or that you'll need to do, there's a packet there's a form in your packet called a rental assistance form. You'll need to fill that out, list who you applied with, and any tracking number or account number for that application. You need to submit that to the court by Wednesday. I will adjourn this matter out to August 21st, 2026 at 3 p.m. That's an in-person hearing, so I'll need to see you down at the courthouse. Okay, sir?
All right. And then I have a new job now too. So I do plan on, if they don't pay for it, I'll pay for it myself at that point.
All right. Very good.
All right.
Okay. And you can always contact plaintiff's counsel's office, see if you can work out some type of an agreement or payment plan. All right.
Okay. Thank you, sir.
Thank you. Lakestone Apartments versus Aisha Frederick.
Hey, please, Honorable Court, Steve Gann, P78219 for the plaintiff.
She is here, I think. I see her. Okay, good morning. All right. What is the plaintiff's claim in this case?
Your Honor, the current balance is $1,884.59. That's $1,884.59. We have court fees of $225 for a balance of $2,109.59. $2,109.59.
Got it. All right. Ms. Frederick, how are you intending on getting that paid?
Your Honor, I'm trying to apply for the SER and rental assistant too. I do plan on paying this.
All right. So if you applied for SER,
no, I
need to
apply, sir. I would like to apply for that.
Okay, then you'll need to get that accomplished. You can apply for that. How many people are in your unit?
4.
4. Okay. So that you know, if you get the maximum benefit on an SER, that'd be $740. All right. So that is just so it's a misnomer to say it's state emergency relief because it won't cover the whole balance. So I try to let people know what the maximum benefit will be on that. So if you apply for that, you'll get a tracking number. And there's a form in your packet called a rental assistance form. You'll need to fill that out and submit it to the court by Wednesday. Okay? All right. And then feel free to reach out to Hawk and other agencies to see if they can assist you.
Okay, yes, I do plan on to do something like a payment plan or whatever, but I will do that, sir. Thank you.
All right. And let me ask you this, ma'am. You have there are 4 minors in your house?
3 minors. It's 4 total, including me.
Okay, you and 3 minors.
Yes.
All right. Are you receiving support for those individuals or no? Or is that an issue
support
for
at
you?
all. No support.
Is that an issue for you?
It is, yes.
And the reason that I'm asking is we have one of the things that we have here is we have someone from the front of the court on the Zoom in the morning on these hearings. So if that's part of the issue for you in terms of trying to maintain your rent, if you wanted to speak with somebody from the front of the court, we'll be more than happy to put you in a breakout room with them so you can start that process if that's what you want to do.
Yes, I would like to do that. So my income decreased, so that's the reason why I'm backed up on my rent. But there's a lot of things. I would like to also seek legal aid. It's just been a lot of things that's been.
I gotcha.
Yeah.
Okay, let's try to take it one step at a time. So who's here with me? Kylie.
Good morning, Judge.
Good morning. What I'm going to do is Ms. Frederick said she'd like to speak with you, so I put you into a breakout room and let's see if we can get something going for her.
Sounds great.
All right. So, Ms. Frederick, I'm going to adjourn your case out to August 21st, 2026 at 3 p.m. That's an in-person hearing. Okay, so you'll need to be down at the courthouse.
Okay, thank you.
All right. So get the SER started and we'll put you into a breakout room with Ms. Hula and see what can come of that also. Okay.
Okay, thank you, Anna.
Thank you. Lakestone Apartments versus Casey Lane.
May it please record Steve Gann for the plaintiff.
Hi, I'm here.
Oh, there she is. Okay. And good morning, Miss Lane.
Good morning.
All right. Mr. Gann, what is the claim in this case?
The current balance is $1,940. That's $1,940 on rent, $225 in court fees for a total of $2,165.
All right. Ms. Lane, how are you intending on getting that paid?
Okay, so I applied for the state emergency relief and I got approved for $1,480. I have to pay $860. So they gave me until September 8th to get those payments in, the $860.
Okay, so ma'am, so that you understand something. What they're telling you is they're not going to pay that until you get that portion paid.
Right.
All right. That offer, if you will, expires on September 8th.
Right.
The
correct.
problem will be is that you will, by September 8th, new rent will add on to your account.
Yeah.
So
yeah.
While that might be paid, you still will be owing.
Oh, yeah, exactly. It's an ever-ending cycle. Yeah. So I do plan on getting that paid. I'm also working with, I have a caseworker from SOS who I'm working with to help me get the rest of it paid. It was.
Okay. So here's what I'm going to do.
Yeah.
I'm going to adjourn this out to August 21st, 2026 at 3 p.m. That's an in-person hearing. you'll need to fill out the rental assistance form. Let us know what agencies you applied to. That form is in your packet. You'll need to supply that to the court by next Wednesday.
Okay.
Okay? And we'll
Okay.
see you in a week.
All right. Thank you. And you said 3 p.m., correct?
Yes, ma'am.
Okay. All right. See you then. Thank you.
Yes, ma'am. All right. Mr. Gann, I think that's it for you.
That is for the morning session. The afternoon session, you're going to be very happy. It's going to be covered by Samantha Sprague. So you have a great weekend.
Hey, I won't see you. I actually wore green and white just in honor of you.
Did you take some Benadryl or something to keep the hives away?
Yeah, well, it's kind of tight around my neck and it's trying to kill me, but it's okay.
Have a great day, Your Honor.
You do the same. Peninsula Place versus Tanya Jimerson.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Good morning, Miss Austin. Is Miss Jimerson here? Oh, there she is.
I'm here.
All right. Okay, what is the plaintiff's claim in this case?
A non-payment of rent case, Your Honor. There's currently past due rent with costs of $2,473.30.
All right. Miss Jimerson, how are you going to get that paid?
So right now, I do have my job. They had me fill out a hardship form, and they're willing to pay up to $1,500 of that, long as I'm a full-time employee, and I am. And I've been there for over a year. But right now I'm willing to. So they're willing to pay the July's rent that I'm behind, but this August rent, I'm focused on that. Like, I'm willing to pay that, but with my paychecks. But due to me not going to work, due to my mental and having problems right now, I do got FMLA, so I will have my full checks in the next 2 weeks or whatever. So I will be able to pay that, but
all right.
I'm working.
So here's what I'm gonna do in your case. It sounds like you've got a plan. So I'm going to adjourn this out to the 21st, 2026 at 12 noon. All right. That's an in-person hearing. I'm going to suggest either that you contact plaintiff's counsel's office or, oh, there she is, Holly. See if you can work something out. Okay. Because it sounds like if you get the hardship and then you have your checks, you may be able to get this resolved at least through that month. Okay.
yes. Well, thank you.
All right. That's an in-person hearing. So we'll see you then.
Okay. Thank you.
Thank you. Peninsula Place versus Eli Burrell.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Burrell, they are not checked in. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor.
All right, go ahead.
Your Honor, request a default judgment for possession only, rent to retain $2,729.35, court cost of $177.72, for a judgment of $2,907.07.
All right, judgment to the plaintiff. By default for possession, redemption amount in the amount requested, writ to issue in 10 days.
Thank you, Your Honor.
Thank you. Peninsula Place versus John Robinson.
Rebecca Austin for plaintiff, Your Honor.
John Robinson, no response. You may proceed.
Your Honor, request a default judgment for possession only, rent to retain $2,863.04, court cost of $177.72, for judgment of $3,040.76.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days.
Thank you, Your Honor.
Peninsula Place versus Shatoya Cooper.
Rebecca Austin for plaintiff, Your Honor.
Shatoya Cooper, no response. You may proceed.
Your Honor, to request a default judgment for possession only, rent to retain $1,295.03, court costs of $177.72, for judgment of $1,472.75.
Judgment to the plaintiff by default possession, redemption amount in the amount requested, writ issue in 10 days. Peninsula Place versus Brandon Bowe.
Rebecca Austin, Your Honor, for plaintiff, Your Honor, we're going to be dismissing this case.
All right, Mr. Bowe. Not responding, but case dismissed.
Thank you, Your Honor.
I'm here. Sorry.
All right.
I'm here.
They're dismissing your case, Mr. Bowe.
Okay, thank you.
Thank you.
All right, bye-bye.
Bye-bye. Peninsula Place versus Wade Robinson.
Rebecca Austin for plaintiff, Your Honor. We are also going to be dismissing Mr. Robinson's case.
All right, Mr. Robinson, they're dismissing your case.
All right.
You okay with that?
Sounds good to me.
Yes, that's okay. That case is dismissed. You have a good weekend.
As well, thank you.
Peninsula Place versus Julius Stewart.
Good morning, Your Honor. Rebecca Austin for plaintiff. We are also going to be dismissing Mr. Stewart's case.
They're not here, though. Okay, that case is dismissed. Plaintiff's motion without purpose.
Thank you, Your Honor.
Peninsula Place versus Timothy Frank.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Here.
All right. I thought I heard somebody.
How you doing?
Oh, there he is.
How you doing?
All right. And what is the plaintiff's claim in this case?
Non-payment of rent case, Your Honor. Mr. Frank currently owes $1,611.53. That does include court costs.
All right. Sir, how are you intending on getting that paid?
How you doing? So I basically plan on paying this by just working. And fortunately, since school is coming up, I'm getting a refund of $6,635. So that should be coming by the end of August. So I'll have this more than paid upcoming. So I'm not really worried about it.
So you got a refund on your student loan?
No, it's basically I work at Amazon and they give you a scholarship. Right, just you gotta love Amazon. So
Amazon?
Yeah.
What are you? You're in one of those trucks?
No, I work in a warehouse, Excel warehouse.
Oh, okay, good. Because I got to complain about the trucks. I'm just saying they need to learn how to turn around in my driveway. But all right, so you got that, and so you're going to be able to get this paid off. You think?
Yes. Oh, for sure.
Okay, so here's what I'm going to suggest that you do. I'm going to adjourn it out 1 week to the 21st, 2026 at 12 noon. Okay.
Mm-hmm.
That's an in-person hearing, so you'll need to come down to the courthouse. But what I'm going to suggest you do, and I don't know, Miss Austin, do you want them to contact Holly directly rather than you, or how you want that?
Holly can take care of everything, Your Honor.
All right. Yeah, I know. She's really good at that.
She's in charge.
What you'll need to do is contact the office, talk to Holly, see what you can work out on this. Okay, young man?
Okay. Thank you. I appreciate it.
All right. Take care.
You too.
Are you in school at Eastern?
Yes, I am.
What are you going to be when you grow up?
I plan on being the best real estate agent in Michigan.
Say again?
I plan on being the best real estate agent in Michigan.
Okay. All right. Real good. All right, young man. You take care. We'll see you next week.
All right. Thank you. I appreciate it.
Thank you. Peninsula Place versus Shayla Taylor.
Good morning, Your Honor.
Good morning, Ms. Taylor.
Thank you.
All right. And what is the claim?
I'm Your Honor, non-payment of rent currently past due $1,012.56. That includes court costs and also includes the $800 payment Ms. Taylor made this morning or last night.
Okay, so it's already taken that off. Okay. All right, Ms. Taylor, how are we going to get the rest of this paid?
Well, I just started a new job again.
Okay.
I'm working at the University of Michigan. I just got my first check today, so I paid the $800. I get paid again on the 28th, so I'll go ahead and take care of the rest by then. I want to do it before then, but that's when I get my next check. But I'm also waiting on some support payments for my son and stuff like that. So I've just been a little behind.
Okay, so let's do this. I'll adjourn you out 1 week because that's what I could adjourn you out to. So the 21st, 2026 at 12 noon. Okay. And then we'll see if there's an agreement or something, we can go from there. Now, with reference to the support payments, is there a difficulty with you receiving them or some other problem or?
It's just a delay. Like it's already in the process, but it's a delay on it.
Okay. So the reason I'm asking is we have somebody from the front of the court. Did you want to talk to them and see about what's going on there or?
Well, no, I could just call my case manager. I'll probably just check in with her soon, see what's going on.
Okay.
But thank you.
All right. You're more than welcome. All right. Then we'll see you in a week at noon.
Gotcha. Thank you so much. Have a good one.
Thank you. You do the same.
Thank you.
Peninsula Place versus Zaria Goss.
Rebecca Austin for plaintiff, Your Honor.
I think she's here. Yep, there she is. Good morning, Ms. Goss.
Good morning.
All right. What is plaintiff's claim in this case?
Non-payment of rent case, Your Honor. There's currently past due rent and costs of $1,395.04.
All right. Ms. Goss, how are you intending on getting that paid?
I just picked up more shifts. I was behind because I was in the hospital for about a week and a half. So it kind of set me back.
Okay. So you think you can get this paid by when or?
The next time I get paid is on the 19th, August the 19th. So I feel like I'll have it by then.
You think so? Okay.
Yeah.
So here's what I'll do then. I'll adjourn it out to the 21st, 2026 at 12 noon. That's an in-person hearing, but if you have everything paid and you're sure you got everything paid, I don't need to see you. You don't need to come down. All right?
Yep.
Okay, very good. You have a great weekend.
You too. Thank you.
Peninsula Place versus Quinita Clark.
Rebecca Austin for plaintiff, Your Honor.
Clark, they are not here. You've been sworn. You may proceed.
Your Honor, requested a default judgment for possession only, rent to retain $1,633.26. Court cost of $177.72 for a judgment of $1,920.98.
Judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days.
Thank you, Your Honor.
Thank you. Peninsula Place versus, is it Jael Grote?
Present, Your Honor.
Oh, there you are. Okay. I will need a cameraman. All right. What is plaintiff's claim?
It's a non-payment of rent case, Your Honor. There's currently past due rent of $1,028.86, and that includes the court costs.
All right. And how are you intending on getting this paid?
Hello, Your Honor. Are you able to hear me?
Yes, we can hear you.
Oh, okay. I apologize. I was having some issues with my technology here. So I
Me
did...
too. That is okay.
Okay. Thank you. It was just a temporary reduction in income. I lost my job back in March. I was able to get back up on my feet and work for myself, but I was having a difficult time balancing being a full-time student and maintaining, but I resolved all those issues. I rescheduled everything, so everything will be paid. I can make a payment today. It was just with that job loss, I kind of had to catch up a little bit.
Yeah.
Yep. Yes, sir.
All right. So how much can you pay today?
Yes, sir. I would be able to make a payment of $500 today, and then the remainder would be able to be paid by next week, Wednesday.
Okay. And then you have the balance by the 19th, I think it is.
Yes, Your Honor.
Okay. That sounds good. What I'm going to do is I'm going to adjourn this out to August 21st, 2026 at 12 noon. if you have everything paid, you don't, that's an in-person hearing. But if you have everything paid, you don't need to come down to the courthouse because they're going to dismiss your case, okay?
Okay, thank you, Your Honor.
You're welcome. You're in school?
Yes, Your Honor. Yep.
All right, what are you gonna, I always try to ask, what are you gonna be when you grow up?
I want to be an audio engineer, so I want to produce soundtracks for Disney, ideally.
For Disney?
Yes, sir.
My court coordinator will love you for that. She is a big Mickey fan. I don't like Mickey. I'm a Donald Duck.
Hey.
Yeah,
I love Donald Duck. He's my favorite too. Yeah.
He's better than Mickey.
Oh yeah,
that's
absolutely. Hey, I was gonna say Goofy always got me, but I do love Donald.
That's my Bayless favorite.
Okay.
I don't know. I don't know if that's I don't know if that's true. I just said it. But, all right.
Thank you so much, Your
young
Honor. I
lady.
appreciate it.
You
Have a
take
great
care.
day. Thank you. You too. Bye-bye.
Peninsula Place versus Krista Beasley.
Rebecca Oscar for plaintiff, Your Honor.
Good morning, Your Honor.
And she is here. Good morning, Ms. Beasley. All right. What is plaintiff's claim?
The non-payment of rent case, Your Honor, there's currently past due rent and costs of $728.61.
Now there's 51 cents. All right, Mrs. Beasley, how are we going to get this resolved?
So I just started a new job a couple of weeks ago. My current job, they were cutting hours really badly. I went from like 30 hours to like 14. So I wasn't able, I got behind on that. So I did make a payment, I believe last Thursday, a money order to the Peninsula Place office. So I am planning on next week getting my next check from my new job. Hopefully I'll be able to pay down the rest of that by then.
Okay, so you're waiting on a check. What day does your check normally arrive?
Wednesday, so it should be the 19th.
On the 19th?
Yes.
And you're hoping you can get the whole balance that's now due paid by then?
Yes, I'm also trying to see if I'm getting a refund from school as well. So hopefully that comes through.
I love this. I love this time of year because students there, your life depends on a refund.
Yes.
All right. So, all right. Here's what I'm going to do, young lady. I'm going to adjourn this out August 21st, 2026 at 12 noon. That's an in-person hearing. So you'll need to come down to the courthouse. Okay. If everything's not paid. If everything is paid by then, and just make sure that it is, I don't need to see you at that point in time.
Okay. Thank you so much.
Okay. What are you going to do when you get that degree?
I want to be a real estate agent, have my own brokerage and everything. So yeah.
Really?
Yes.
Why?
Why?
Why you want to do that?
Because I like the market. I like to talk to people. I've been wanting to do that for a while. Like since I was in high school, I started learning about it. So yeah.
Okay, fantastic. Always follow your dreams. You like to talk to people. I don't like talking to people. That maybe it's the wrong job.
Right.
All right. You take care, young lady.
You as well. Thank you.
Peninsula Place versus Isis Cunningham.
I'm here, Your Honor.
Oh, there you are. Okay. All right. What is the plaintiff's claim in this case?
A non-payment of rent case, Your Honor, there's currently past due rent and costs of $1,877.90.
All right. Ms. Cunningham, how are you intending on getting that paid?
By next week, I'll be able to pay $1,200 on it. Then I get paid the following week to repay the remainder balance.
Okay. So next week you can get $1,200 paid.
Yes.
All right. So here's what I'll do. I'll adjourn this out to August 21st, 2026 at 12 noon.
Your Honor, is it possible to do like a later time because I work that day and because it's like such a week in advance, I don't know if I'd be able to get there by 12.
Really? Nobody gave me a problem till her. All right. Here's what Miss Are you able to sign on to Zoom at work?
Yeah, I'm at work right now.
Okay, so here's what I'm going to suggest you do. Fill out get online. I think you can get one, a Zoom form, fill it out, and we'll look at it and see if we can approve it so that you don't miss work.
Okay. What's the, like, if I fill that out today and get it in, how long do you think? That way I'll just like plan in advance if it doesn't get approved.
Are you a student?
Yeah.
Yeah, you're asking a lot of questions. All right. Pardon? It's going to be at noon either way. Okay.
Oh, okay. Yeah, I just want to know because if it doesn't get approved for the Zoom, then I'll plan to call out sick or something.
What are you going to be when you grow up?
I'm in school for secondary education, so to become a teacher.
Okay. So wants to be a teacher. That's why she's like giving me a hard time here. Here's the thing, Ms. Cunningham, I love teachers. My parents were teachers. I was a teacher. I'm going to tell you what we're going to do. I'm just going to do this, and I'm going to get myself in trouble for doing it. Just get the form in. We'll approve you for Zoom. That way you won't miss work. And as long as you get the $1,200 paid, we'll approve you for Zoom. How about that?
Okay, awesome.
Sounds good?
Yes, thank you so much.
You're welcome. You have a great weekend.
You too. Thank you.
Thank you. And I think as counsel, is that it for you?
It is until 3:00, Your Honor, that I will see you in person.
All right. Fantastic. Look forward to it. Thank you. Holly, are you going to be here or are you not?
I will be there at 3.
Okay. All right. Then I won't say goodbye to you. All right. Thank you. We'll see you then. Felix Robertson versus Todd Pardon.
Here, Your Honor.
All right. There, and I think, Mr. Pardon, I got the other one too. Okay. This is a termination case?
Yes, Your Honor.
All right. Is there a written lease?
Yes, there was a written month-to-month lease. So this home was initially stated for month-to-month for traveling nursing and medical professionals. So there was a month-to-month for the medical professionals as they transition between University of Michigan and St. John. So he was recommended through a realtor who recommended him, and he's been there for approximately 4 months. So.
Okay, and there I see on here. Okay, so here's part of the problem. I don't know what the lease indicates because I didn't get a copy of the lease, but because it just indicates that the basis for the termination is a lease violation, and then in parentheses it says nuisance, and I don't know what that means.
Yeah. So there was a police response to the home where 6 cop cars responded and provided a disturbance in the neighborhood. So there's a firearm involved, and I think he was taken into custody at that time. So with that disturbance, there was decided not to extend the lease for another month. So I served him with a notice to terminate the lease.
Well, whether or not that constitutes a valid reason, I'll have to decide. Mr. Park, what's your position?
Yes, can you hear me, sir? Your Honor?
Yes, I can hear you.
Okay, great. Yeah, what happened is I was extremely depressed. I ended up calling the police.
Hold on, Mr. Park. Hey. Is there a criminal proceeding at this point?
Nope, nothing. I've already called and spoke to everything. Nothing happened. I ended up trying to do, I guess it's called swatting, suicide by cop, but I didn't follow through with it. They arrested me and they said, do you want to go to jail or go get some help? And I said, go get some help. So they just took me by ambulance to University of Michigan Hospital. They said I was been extremely depressed, so they put me on medication. I was in the hospital for almost a month, got back home, and there was a letter from the landlord who's been great with us, Felix, saying that the neighbors were kind of scared with what happened. I wasn't arrested or anything like that. They just committed me for it.
Okay.
And I'll be out by the end of the month.
You're gonna
But
leave?
there's currently no lease though, and there's been no payment of rent for June, July, or August. So it's freaking a financial hardship with me.
Mr. Robertson?
Yes.
He said he would be out. You're going to get out by the end of the month, sir?
Yes. And I spoke to him about that. He said he was going to use some of the money from the security deposit towards that and that I didn't owe him anything. Well, we haven't even, I moved in and I've got all my furniture and everything from my previous house still in the garage. So it's going to be very quick. I'm just going to be out by the end of the month and he can take repossession of the place.
Okay. So here's what I'm going to do. I'm going to adjourn this out to the 21st, 2026 at 12 noon.
Okay.
That's an in-person hearing. So
okay,
the
the 26th, 12
to see if
noon.
we could work. I'm sorry.
Okay, it was the 26th at noon?
No, the 21st.
Oh, 21st. Okay.
Your Honor, I'll be out of the country.
Okay. Well, I don't know what you want me to do then.
So I can have somebody stand in for me, a family member?
No, unless they're an attorney.
Okay, I'll have an attorney.
All right. Have an attorney, and I'm going to suggest, since you're willing to move out, maybe you guys can work out an agreement or do something. It just sounds to me like this gentleman was suffering from a mental health crisis, got some help, and he's willing to kind of move on. So I think you guys can figure it out. If you can't figure it out, come down. I'll figure it out for you. All right. Thank you. We'll see you next week.
Okay. Thank you.
Thank you. That's it for this block. 14A stands in recess. We'll come back and set our 10 o'clock block momentarily. Let's call the case. All right, very good. What is plaintiff's claim?
Total, including costs, is 1565.84.
1565.84.
Yes, sir.
All right, sir. How are you intending on getting that paid?
I'm intending on getting that paid pretty soon. This Friday coming up. I missed one rent payment and I'm currently on two, but I plan to pay it as soon as possible.
Okay. How much are you gonna be able to pay by next Friday?
$695.
69, 695.
Yeah, I can pay half.
All right. Well, that's not quite half, but I got you.
Yeah.
All right. So what I will do is I'll adjourn this out to August 21st, 2026 at 1 p.m. That's an in-person proceeding. So if everything's not paid, you'll need to come down to the court and see what we can work out. All right?
Yes, sir. Thank you, Your Honor.
All right. Thank you. Thank you.
Thank you.
Sile Farms versus Lauren Eccles.
Good morning, Your Honor. Rachel Dornbush, Pallets Law, P78301 on behalf of the plaintiff.
Lauren Eccles.
Okay, there you are. All right. What is plaintiff's claim?
With cost, Your Honor, $2,642.51.
All right. Ms. Eccles, how are you intending on getting that paid?
I can pay $1,500 tomorrow, and then I get paid again on Tuesday.
So you can pay $1,500 tomorrow, the 15th. And then you get paid again on Tuesday, and you're going to be able to cover the balance at that time, or
yes.
Just going to? Okay, and then the balance by the, what's that, 17th?
19th, maybe?
18th.
Oh, 18th, yeah.
Okay, so the balance by the 18th. Okay, fantastic. What I will do is I'll adjourn it out to August 21st, 2026 at 1 p.m. That's an in-person hearing, but if you have everything paid, you don't need to come down to the court, okay?
Okay, thank you.
Thank you. Have a great weekend. Sile Farms versus Daniel Williams and Williams and Daniel Bleffett. Neither have checked in. If you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Again, for the record, Rachel Dornbush, Palace Law, on behalf of the plaintiff. There is rent to retain of $2,187.87. Costs are $233 for a total due of $2,420.87. We'd ask for a default possession only judgment with a writ to issue after 10 days.
Judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested with the writ to issue in 10 days. I think that's it for the morning. Eh?
It is indeed. I'll see you at noon. Thank you.
All right. Arbor Manor versus Alicia Blackman.
Larissa Gazzari for plaintiff. Good morning.
Good morning. Not checked in. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Your Honor, the rent to retain possession is $2,355.39. Court costs of $175 for a total redemption of $2,530.39. Plaintiffs requesting entry of a default judgment with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days.
Thank you.
What is Court does call the case of Forrest Knoll versus Deja Bibbins.
Larissa Gazzari for plaintiff.
Deja Bibbins.
Okay. All right. Hello. All right. What is plaintiff's claim?
Your Honor, the outstanding balance is $915, which includes court costs.
$915. All right. Ms. Bibbins, how are you intending on getting that paid?
Okay, I can pay $534 today, then I could pay $200 on next Thursday when I get paid, because I've been working, so I've been sick. And then I can get the rest of the money probably the week after. I didn't know it was that far up. I didn't know it was that much up. I just knew about the $740.
Oh, okay. I see what you're saying. You were doing everything but for cost.
Yeah.
Right. Okay, I understand. So you're going to have $534 today, $200 by, you said Thursday, the 19th?
Yes.
No, yeah, the 20th. All right, $200 by the 20th. Okay, and what I'll do is I'll adjourn it out to August 21st, 2026 at 2 p.m. That's an in-person hearing. So if everything's not paid, we'll need to see you at that hearing. Feel free also to contact the plaintiff's counsel's office and see if you can work something out prior to that time so you don't miss work.
Okay, thank you. Also, can you tell me the remaining after I paid the $740? How much would that be?
If you pay you said $740 or $534?
If I paid the $534 today and $200 on next Thursday, how much do I have left over to pay for the courts and fees?
You want two lawyers to do math? No.
I'm sorry.
Hang on a second. I need 915 minus 734.
181.
181.
Oh, okay. Yeah, I have that. Thank you.
Okay. All right.
You have a great one.
Yeah. Forrest Knoll versus Ashley Douglas. And Elijah Douglas.
Hi.
Oh. Sorry, go ahead.
I think she got it in. Yeah, Ms. Douglas is here. All right. Okay, how much is owing on this?
Your Honor, the outstanding balance is $1,971, which includes court costs.
Okay. Ms. Douglas, how are you intending on getting this paid?
I reached out to Hawk and I reached out to other rental assistance agencies. On last night, I submitted an SCR application. I have not got a response back from either agency as of yet.
Okay.
I am willing, though. I will be able to pay $1,512 as about September 3rd. I'll be able to pay that of my own.
I gotcha. Okay, but then your September rent's going to click in. So let's do this and see what we can do. I'm going to adjourn your case out to August 21st, 2026 at 2 p.m. Okay, that's an in-person hearing. So you'll need
Okay.
to come down to the courthouse. And then you'll need in your rental packet, there's a rental assistance form.
Okay.
You'll need to fill that out, put your SCR tracking number on there, as well as just note that you contacted Hawk and submit that to the court by this upcoming Wednesday.
Okay.
Okay?
All righty.
All right. We'll see you next week.
Thank you.
Thank you. Hamilton Crossing 2 versus Rashawn Page.
Marissa Gazeri for plaintiff.
Oh, I think that's Mr. Page. Yep, that's him. All right. Okay, what is plaintiff's claim?
Your Honor, the outstanding balance is $4,621, which includes court costs.
All right. Sir, how are you intending on getting that paid?
I'm also waiting on some agencies. They haven't got back with me yet neither to help me pay for that, but I do have half I can pay next Friday, but I'm still needing a little assistance.
All right. So how much are you going to pay next Friday?
I can pay $2,000 next Friday.
$2,000 next Friday.
Yes,
All
sir.
right, the 21st. Okay. Okay, so whatever agencies you're working with, the rental assistance form that's in your packet would need to be filled out. Those would have to be listed and supplied. You have to file that with the court by Wednesday, okay?
Okay, no problem.
Get the $2,000 paid. Pay that as early in the day as you can, okay?
Okay, will do.
All right. And I'll adjourn your case out to next Friday, the 21st, 2026 at 2 p.m. That's an in-person hearing, so you'll need to come down to the courthouse. All right?
Okay, I will. Okay. Thank you.
Always feel free. You can also contact the plaintiff's counsel's office and see if you can work out something, okay?
Okay, will do. Thank you.
All right. Thank you. Hamilton Crossing 2 versus Sharice Meyer.
Marissa Gazeri for plaintiff.
Good morning, Sharice Meyer.
There she is. All right. What is plaintiff's claim?
Your Honor, the outstanding balance is $1,766, which includes court costs. For Ms. Meyer's case, the parties are in the process of negotiating a conditional order of dismissal. So I'm asking for a 1-week adjournment just to allow time for that to get signed and submitted to the court.
And Ms. Meyer, is that correct?
Yes, Your Honor, I've made the first payment of that order. As a matter of fact, the second payment is due on the 25th.
Okay. So she got things taken care of before she even showed up to see me. What is that about? All right. All right. Ma'am, I'll adjourn your case out to August 21st, 2026 at 2 p.m. That's an in-person hearing. Okay?
Okay, if I'm sorry, I just need to make sure if I'm in an active COD with them, I still need to show up.
Yeah, I'll need to see you only because I have to question you regarding the terms.
Okay.
Okay?
Okay.
Well, you don't want to come see me? Yeah, you're trying to hurt my feelings. That's okay.
Not today, Mr. Judge Simpson, not today.
Okay. All right. You take care.
Thank you, you too.
Hamilton Crossing 2 versus Jessica Jackson.
Marissa Gazeri for plaintiff.
I think she's here. All right. All right. What is plaintiff's claim in the case?
Your Honor, the outstanding balance is $2,405, which includes court costs.
All right. Ms. Jackson, how are you intending on getting that paid?
Good morning. Can you hear me?
Yes, we can hear you. You're good.
Okay, I paid $300 yesterday. I should have another $400 next week. I lost my only transportation. My car got destroyed. Therefore, I lost my other job. But I have a new job that starts on the 24th. She said for me to keep making payments and she'll work with me. Because right now I work at McDonald's and I'm only making $15 an hour and I'm getting less than 30 hours a week.
Gotcha. Okay, so here's what I'm going to do. I'm going to adjourn this out to the 21st, next Friday, 2026 at 2 p.m. That's an in-person hearing, so you'll need to be at the courthouse. I'm going to suggest maybe if something can be worked out regarding payments, that you contact plaintiff's counsel's office to see if they're amenable to a conditional order dismissal or some other type of agreement. Okay?
Yes, sir. And I want to take my condolences to you and your family.
To me and my family?
Uh-huh.
Okay, why would you say that? Are you talking about my good friend Lauren Brown that I lost?
Yeah.
Yeah. Oh, well, thank you very much for that. Yeah, he was like family to me, but
Yeah.
I do appreciate that and your thoughts.
No,
All right.
no problem, Judge. Have a good weekend. Thank you.
Thank you. Hamilton Crossing 2 versus Christina Morgan.
Marissa Gazzari for plaintiff.
Christina Morgan, not checked in. I did swear her, correct?
Yes.
All right, you may proceed.
Thank you, Your Honor. The rent to retain possession is $457.86. Court costs of $176 for a total redemption of $633.86. Plaintiffs requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days.
Thank you.
Hamilton Crossing 2 versus Tanisha Ballard.
Marissa Gazzari for plaintiff.
Is she? Oh, there she is. All right. Good morning, Miss Ballard.
Hi.
All right. What is plaintiff's claim?
Your Honor, the outstanding balance is $1,968, which includes court costs. In this case, the parties are negotiating a conditional order of dismissal. So we are requesting a 1-week adjournment to get that signed and submitted to the court.
All right. And Ms. Ballard, is all of that correct?
Yes.
All right. So I'll adjourn it out to the 21st of August, 2 p.m. That's an in-person hearing. You'll need to be here so that I can ask you questions regarding the conditional order dismissal. Okay?
Okay, thank you.
All right. Thank you. Hamilton Crossing 2 versus Nicole Blasco.
Marissa Gazzari for plaintiff.
Nicole Blasco, no response. You may proceed.
Thank you, Your Honor. The rent to retain possession is $1,990. Court costs of $176 for a total redemption of $2,166. Plaintiffs requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with the writ to issue in 10 days. New Park Ridge Apartments versus Nicole Townsend.
Marissa Gazzari for plaintiff.
Nicole Townsend, not here. You may proceed.
Thank you, Your Honor. The rent to retain possession is $108.92. Court costs of $176 for a total redemption of $284.92. Plaintiffs requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with a writ to issue in 10 days, no writ without a hearing.
Thank you.
New Park Ridge Apartments versus Aaron Smith.
Marissa Gazzari for plaintiff.
Aaron Smith.
Okay, there you got him. Okay. All right. What is plaintiff's claim in this?
Your Honor, this is a termination of tenancy case. Defendant's tenancy was terminated pursuant to a 1-month notice to quit. Essentially, an audit showed that Mr. Smith did not qualify for housing at move-in due to undisclosed income. He reported that he had started working prior to moving in.
All right. Mr. Smith, what do you have to say about that?
I did report it, but I guess they didn't say anything about that. I did report it. I showed all information, my check stubs too. So I didn't understand that, but they did say they were willing to transfer me. So I actually did all my paperwork for the transfer and just got approved for the transfer yesterday. So I was doing the transfer
to another
Yep. Well, not in this complex, but in with another complex, but it's through the same company.
Okay.
Your Honor,
Ms. Kazari, you know anything about that?
I do not. Let's adjourn 1 week. Let me talk to my client and see if we can work it out.
All right. Sir, I will adjourn this out to August 21st, 2026 at 2 p.m. That's an in-person hearing, so I'll need you to come down to the courthouse, okay?
And what day is that again?
That's next Friday, the 21st, 2 p.m.
Okay, Judge. Thank you.
Thank you. And then Forrest Knoll versus Lachey Miller. That matter is dismissed on plaintiff's motion without prejudice. I'm out of files. I think that's all I have for you.
That's it for me. Thank you, Your Honor. Have a good day.
You do the same. All right, and that ends that block. Thank you, folks, very much. Ms. Hula, thank you very much. Did appreciate your assistance today.
No problem, Judge. Have a great weekend.
You do the same.
Thank you.
Court stands in recess.
Ready to transact business. Good morning, everyone.
Good morning.
This is a return to the matter of Ronnie and Judy Harmon Family Trust versus Greg Lafferty. The file number is 261240SP. This is a land contract possession after forfeiture matter. Cordell Jones represents the plaintiff, Mr. and Mrs. Harmon, and their trust. Greg Lafferty is present by Zoom, as is Mr. Jones. Also, attorney Rhonda Stowers is here on behalf of some intervening parties, the Larsons, Jonathan and Jessica Larson. Can't read my writing. I think it's Jessica.
That's correct, Your Honor.
All right, she's actually filed an appearance on their behalf and is here today. This is a land contract foreclosure action. We had a previous hearing on July 21st. We adjourned the matter until today. We learned that it is alleged that Mr. Lafferty sold the property to the Larsons, and they indicate they paid full price, lump sum, I think, and they've been unable to get title. So here we are. We did adjourn this for several weeks to give the parties an attempt to discuss it further and set it for a larger block of time. Mr. Jones, I'll defer to you. What's the status here today?
Well, the status is we're here today to try and get a judgment on the land contract forfeiture action. We filed with the court today a copy of the payment schedule showing the balance due on the contract, and we provide that to all the parties that are here. They have some problems that they have to take care of, but that doesn't involve us. I think that if we were to get a judgment today, they'd have 90 days to still work those out, and then maybe they'd get the money and pay us, or we'd have the property at that time.
All right, Ms. Stowers, what's your position?
Thank you, Your Honor. Rhonda Stowers on behalf of the Larsons. We did file a motion to intervene this morning in an attempt to try to resolve some of these issues. As the court knows, it allowed adjournment to allow us to try to exchange records. Records were exchanged in that we got the payment log from the Harmon Trust. I supplied the agent file for our closing to both Mr. Lafferty and the Harmon Trust. The issue that we have, at least on behalf of the Larsons, Your Honor, is that Mr. Lafferty was unable to obtain the necessary records from his bank. He's experiencing some pushback on them, and they're wanting specific numbers of checks and things that he simply doesn't have due to his situation that his wife was handling this. She passed away, and he is lacking information in that respect. I've asked in my motion to intervene that the court allow one additional adjournment so that we can subpoena the bank to get those records, to confirm payments that were made, payments that weren't made, so that we have a way of resolving this. If the court enters a foreclosure today, the concern that my clients have is I will no longer have an active action in which to file a subpoena for that information, and we will never be able to obtain that information.
Without filing a separate action against Mr. Lafferty.
And the Harmon Trust, quite frankly, yes. We would have to pull everybody in.
A concern I have is there may be some criminal fraud here, that he's selling property he doesn't have title to. And the Larsons contend that they paid a large sum of money at a closing. Mr. Lafferty is unable to provide title because he doesn't own the property. He has a land contract for it. And that could be something known as larceny by false pretenses or other sort of fraud. So that is lurking in the background. Mr. Jones, I understand you wish to get a judgment, and in a practical terms, the defendant has 90 days to redeem it. They paid less than 50% of the purchase price. And that would give 90 days for the parties to continue to try to work out something. The concern for the Larsons, obviously, they gave Mr. Lafferty $109,000 or something, and so far they got nothing for their money. And he's selling them something that he doesn't own. I guess the Larsons paid $225,000. I don't know where that money went, but it didn't go to the Harmon Trust. But Ms. Stowers' request, I will grant her motion to intervene. Ms. Stowers, what are you looking for from his bank records? What happened to the $225,000?
That would be nice to know, Your Honor, but really my concern right now is confirming what checks were issued to the Harmons so that I can confirm that their payoff log is accurate so that we then know the precise amount that is owed and then can move forward with the resolution at that point.
And then what's the plan?
The plan from our perspective, Your Honor, is to talk to the title carrier and to talk to Mr. Lafferty. And if he doesn't pay, obviously my clients need to protect their interest. And then there will probably be a pursuit of Mr. Lafferty to the extent that there were not payments made. But again, I don't have the ability to do that without that information from the banks. That's pretty critical.
All right, well, how much he owes the Harmons doesn't really appear to be your client's problem. They paid him $225,000 and he's unable to provide the title. How much he owes the Harmons is between him and the Harmons, the way I see it. So I'm not exactly sure why you need that information to continue to represent your client's interests.
It's because, Your Honor, that my clients would be willing, I assume, and again, I'd have to talk to my carrier, but my expectation is my clients would be redeeming on behalf of Mr. Lafferty in order to protect their home.
Yeah,
they would need to make that payment to prevent their home from being basically repoed by the Harmon Trust, at which point they would need to, they don't want to overpay and then pursue Mr. Lafferty for an amount where he says, hey, I paid that to them and it wasn't that much owed. And then we're back dealing with the Harmon Trust again. I think it's a lot smoother to just get this all resolved on the front end. And that way we know that what we're paying the Harmon Trust, if it comes to that, or what Mr. Lafferty's paying the Harmon Trust, if it comes to that, is the amount owed, so that then we know what the different parties' respective, basically, liability is, for lack of a better term.
All right. So your client would be willing to continue to attempt to redeem the land contract and then pursue Mr. Lafferty if it's not paid. But at some point, somebody's got to pay off the Harmons so they can provide a deed to Mr. Lafferty, so Mr. Lafferty can provide a deed to your clients.
That's correct.
Your Honor, may I say something or no?
Yes.
So I had a conversation with Mr. Jones this morning, as well as Ms. Stowers. To simplify this, I want this paid off and done, okay? And we are sitting where we're at now because of a lack of communication with Judy and I. Now, I tried to get it resolved before we came to this, but, Mr. Jones informed me of some things that I was not privy to, as far as the 90-day thing and so forth and so on. My goal is to have this paid off in less than 90 days, because I want this done and over with like I wanted it done and over with a long time ago. There was nothing criminal done here. Everything was done with lawyers and through a title agency and stuff like that. I just want it paid off, and I want to know what I'm paying off. That's what the concern has been for a long time. Or the amount I'm paying off, not what I'm paying off, sorry.
Well, my question is, where's the $225,000? Don't answer that, because there could be criminal fraud here. If you took that $225,000 and went on a round the world trip, if it's sitting somewhere in escrow, sir, we're in a court proceeding. I'm asking you not to.
I'm sorry. It's bad.
Pretend like you're in court here.
Yep, I apologize.
So, tell me again, Ms. Stowers, when was the closing that your clients purchased the house?
1 second, Your Honor, I have to pull that back up.
I believe it was June 7th.
Okay.
Yeah, 6/7 of 2024. At least that's what my files stated.
That leans toward the fraud side. He's had their money for 2 years and hasn't remitted it to the Harmons. So the Harmons have, and then no one's making the payment, so the Harmons are pursuing this foreclosure. I'm very interested to know what happened to $225,000 for 2 years. But your point is that your clients may be willing to redeem the contract to save their house. I guess the Harmons don't care who pays it, as long as somebody pays it. Then you've got an issue with Mr. Lafferty. But I am seriously concerned about the fraud aspect of this. So, Mr. Jones, the world isn't going to come to an end if we adjourn this, but maybe that will also answer the question of where that money went. I had blocked out 45 minutes for this because it was more than just a simple matter to address. Mr. and Mrs. Harmon, I guess for your purposes, the good news is that the Larsons may be willing to try to redeem this, which would get you made whole. But for the Larsons, they're double paying for a property, and they're left having to sue Mr. Lafferty for the money they've paid, which may or may not be somewhere. All right, let's see where we're gonna put this. I'd hope maybe to resolve this today, but I understand her point. And my position is that that's not her problem. She says it may be my problem if we're the ones that are gonna pay it off. So.
We don't have a contract. Mr. Lafferty indicated he'd be able to pay this off in 90 days, so I don't see a reason not to enter the judgment, Your Honor.
Say that again, Mr. Jones.
Mr. Lafferty in his comment indicated that he can pay this off within the 90 days. So I don't see any reason not to take a judgment this time, so we don't have to come back and do this again.
This is the same guy that's held on to this money for 2 years and not transferred it. So I'm not sure I'm going to take him at his word that he's going to pay the money within 90 days. It's easy to say it. If he had the money, he should be able to pay it tomorrow, not 90 days from now. But I certainly see your point, but the world's not going to come to an end if I adjourn this for 2 weeks. I'm going to adjourn it to Friday, August 28th at 11 o'clock. Hopefully that's enough time to get these records.
Can you
Your
repeat
Honor,
that,
under
Your Honor?
the, sorry, Mr. Lafferty. Under the court rules, Your Honor, I have to give 14 days notice on a subpoena to produce records. I don't know that the bank's going to get back to me. Even if I issue the subpoena today and serve it, I'm not going to have the records by 2 weeks.
Well, that mitigates toward me just granting the judgment, but I'll swallow the whole pill here. Friday, September 11th at 11 a.m.
At 11 a.m., Your Honor?
Yes, we'll block out 1 hour.
Friday, September 11th. 11 a.m.
Now, Ms. Stowers has Mr. Jones's payment logs, so she can see what they show as having been paid. Those logs end on 8/26. Well, let me see, the last payment was made July of 25. Apparently no payment has been made since August of 2025. Well, wait a minute, there was a $1,000 payment in January of 26.
Bound 25.
That check bounced though.
The bit bounced.
Oh, the check bounced, okay.
Yes.
So it did come in as zero. So no payment has been made in a year.
He says.
That's after Mr. Lafferty received the $225,000 from the Larsons. The more I look at this, the more it looks like fraud. But I'm not sure what you're going to find from his bank records, but you may inadvertently find out where the money went. So I'm going to adjourn this. Mr. Harmon, it delays your judgment by about 28 days. And for that, I'm sorry. But if the defendant, or excuse me, if the Larsons are going to pay it, they want to make sure they've got an accurate figure. Now, Mr. Lafferty's can put up or shut up. He should have $225,000 to apply to this. Maybe the whole thing can be resolved. At any rate, somewhat reluctantly, I'm going to continue this matter for 28 days to September 11th at 11 o'clock. We'll block out the whole hour. Then we'll have an agreed upon number of what should go in the foreclosure order, forfeiture order. And the date would be 90 days from that date, from September 11th, rather than 90 days from today. All right, I'm sorry if everybody didn't get what they want, but that's, I think, is maybe a little closer to the finish line. Mr. Lafferty, you can, in the meantime, pursue paying off the Harmons, getting a title that you can transfer to the Larsons and make everybody happy. All right. If not, you may have a visit from the Michigan State Police, but we'll see where this goes. All right, thank you all.
Thank you, Your Honor.
Thank you.
Thank you.
Yes. So, what is it, Groundhog Day? When he came in, then he looked around, then he went back out.
More like whack-a-mole.
Did you come in, see your shadow, and then you?
I turned around.
Turned around and left. I think.
You know, there is one.
It's Prevost, Mr. Prevost.
Yes, that's what started. How you doing, sis?
I'm okay. What about you?
Much better, much better.
Much better than yesterday?
Than yesterday. Yesterday was tough. I was drained. That sun was killing me. The sun was tough yesterday.
That's fine.
I know, right? You can't drink a lot of water.
You can't get up and soar with the eagles when you stay up late all night hooting with the owls.
It doesn't work together.
Yeah.
Actually, I'm looking at Mr. Prevost's motions, and they're all about this new indictment, right? Looks like that's correct. One and only thing out of each of these two motions, and then the new substantive offense of driving while intoxicated with a child passenger.
Judge, you gonna point me on the new case? I know I'm on MTRP, and I do have the motion of revolt. And I gave them that, and I also did get the probable cause affidavit that I think was the hand put with this. But on the new offense itself, am I gonna get a point on that as well?
I don't know.
We have you down.
Y'all got me down? That's perfect.
That's down.
I know.
Is he indigent?
Yes, he is.
Do we need to have another indigent affidavit on his behalf?
He should have put one out at the jail, Judge.
I don't have anything in here, though.
Well, it
I
could
don't
be
know
our
what.
electronic file, Judge, you know.
I know I got this one, so we will.
Yeah. Does he have one in the motions? Because if it hadn't changed, no, I don't see any in any of this. You've been on probation for 3.5 years?
No, yes, sir.
I did the math. Looks like it. October 22nd.
Yes, sir.
Going on 4 years. Then this mess happens.
There's an indigent affidavit in the electronic.
What's the date of it?
August 3rd.
Of this year?
Yes.
Okay, all right. But who posted your bond?
My father.
Somebody posted a $10,000 bond.
My father.
No, you owe him.
Yes, sir.
Don't forget.
Yes, sir.
Okay. So he's got, yeah, it's 2 allegations. It's the DWI with a child passenger and then the curfew violation, right?
From the same incident, the time that the wreck occurs here that leads to the DWI was at a time past his curfew.
What was the, was there an alcohol?
0.183. And if you didn't read the PC,
I know.
he hit a cop
5-year-old
car.
child.
And he hit a cop car.
His 5-year-old child was in the car. And you're on 2 deferred or unadjudicated 2nd-degree felonies, which are up to 20 years in each state.
And Your Honor, also just for reference, when you made bond, you did obtain the drug patch, but still to this day, anytime he has been out, he has not obtained GPS.
Yeah, I'm sorry.
He has not obtained the GPS that you ordered.
What she's referencing, Judge, is we had a hearing back in December after his pleas of true, and you decided to give him another opportunity and set some additional conditions with jail time, and he couldn't have been out long before he actually committed this offense. So when the state's ready for whenever you want to set this for a hearing.
When is Mr. Adams ready?
About a year now.
2, 3 weeks.
2, 3 weeks be fine.
We're doing hearings the week of 24th. Be my preference to do it as soon as possible, Judge.
How about 10 days? 2 weeks, 2 weeks.
2 weeks, 2 weeks, at least 2 weeks.
What's his bond right now on all of this?
Probably should be a no bond at this stage, Judge. And the state would ask that it stay that way until we have a hearing.
Even if he posted a bond, he's never gotten a GPS device, which he would have to have had. And he had shown that he could pull that one off. So he's got a lot of problems here that keep him from the free world until we can complete this hearing.
We continue to give him direct help to get that device, and he does not.
All right. Okay. She said there is no bond.
We'd have to remain that way at least until we have a hearing.
Okay.
Thank you.
All right. Well, we said for hearing on this.
Okay.
Thank you.
Thank you, Judge.
Yes, sir.
Hey, Judge, can we do Hernandez next? Please. Probation officers?
Is that John West?
Yeah, John is here.
All probation officers? Okay.
That's everybody in the audience. We'll be right back. Thank you.
Where y'all going?
They're doing new staff pictures. That's why I want to do Hernandez next.
Would you like to take a photo with us?
Oh, they can do it here, up here?
We can up here.
I'd love to.
Cameo.
Y'all been this way. We changed our mind.
I just didn't want to interrupt the.
Come on, Jimmy, can you help me out?
We got a picture first.
I get the picture.
Anybody, a decent picture taker?
I can try.
Okay. Make it.
Hold up, I gotta get my Mary Kay products.
Okay, go get them. All right, come on, Greta. Thank you. Come on. Yeah, and we want to judge our condo about.
I don't know. You ladies use Mary Kay, but I've got the industrial strength. Mary Kay.
Okay, I like it.
Seems so.
I know a lot about Mary Kay. You want to come stand in the middle of it? We'll just surround you.
Just here for the
All
ride.
right, come on, guys. Side. I'm called. This is.
Where do you see that?
Okay, they're gonna stand, you stand right in the middle of them and we're kind of.
Placement.
Yes. And we'll get our.
Oh.
Right, so everyone.
The Associated Press Department.
That's right, you so great. Take several, sir.
Do you have that young filter? There's no critical friends.
I'm a queen of Photoshop, it's fine.
1, 2, 3.
Thank you very much, I appreciate it.
If you see any of these people, don't and yourself.
That's great, thank you. I appreciate it.
Again,
I'll send you a copy.
let me just say, it's always an honor working with you all in this town.
I appreciate you a lot.
Thank you, y'all thought enough about me that you would place my photograph. It's a beautiful lady.
It's not, it's not.
So sending attractive guys.
So, thank you.
What's your figure at me?
And I just love you so.
I'll get you. I was being kind by not taking a motion.
What? Let's go to work.
Yeah. Just for, yeah.
You know, I think I was blinking during that picture.
You were
I was blinking.
Thank you.
All right, Cameron Hernandez, y'all want? And that's going to be John West.
You're going to Zoom, Judge. I just wanted Hernandez because he was the only one that didn't have a probation office. So.
Okay, so what do you want now? With
We can continue where we left off.
All right, it was.
Or we can do Hernandez. It doesn't matter.
It comes in handy for a defense attorney. We don't have one.
Okay, so we have them.
They're an endangered species. First of all, Gary Falk is on the docket, but it's been reset. Says RS not here.
We did a bench warrant and he hadn't been picked up yet.
Why are we warning benches?
Because they keep causing problems in prison.
All they do is sit around.
You have the problem, Cameron? They were being put in that, like that.
Yeah, well, John was on Cameron Hernandez is next up, but we can go to Terry Jackson as well. All of these.
That's kind of work Terry Jackson out if I can. I need one week from now to be here next year. So, I'm making sure John's talking to the guy. We'll see what happens.
He's got 4 people to talk to. So,
yeah.
What about Wilkerson? Is he going to be here with Aaron Wiggins? So a murder case announcement. Okay, what do y'all think's going to on Hernandez? Do we have a hearing on that, or did y'all work a deal? Okay, and then I've got Terry Jackson's cases, and then Shaquille Maxon. That's supposed to be a hearing. Elijah Watson hearing, and then Aaron Wiggins.
Judge, I filed a continuous on Watson. We still don't have a new underlying BWS. And I suspect the same will be with the Maxon case if the underlying law violation hasn't been referred to our office yet.
Well, we're not going to do anything today.
Well, we may, and we'll see what John does. We may work through some cases.
That's why I said the whole week for trying to get. One. No?
I don't think.
Oh, okay, that's in the queue.
Ready to plea on those
And we're not.
That's right.
The list, DWI, fleeing police officer.
Yes, sir.
Failing to provide verification of community service at a location other than residence, and then
Yes, sir.
arrested for failed to abstain from others. That looks like the same thing.
I had a conversation with our first assistant backing out yesterday, Judge. The practice going forward will be, now that I'm assigned to these cases, when the MTRPs are presented to me, if we don't have those new law violations, I won't be following.
What do you mean if we don't have those new law violations?
If we don't have the new cases, the POCSs, the DWIs, anything that we would be waiting for a lab on, if we don't already have it, then the practice going forward will be not to file the MTRP unless or until we get that new law violation.
Oh, okay. Well, okay. But this one's filed nonetheless.
Yes, sir.
And what is it? Which one can't you go on of all these allegations?
I could go on the non-law violation, but here's why I'm hesitant to do that. We had the very same situation here within the last couple of weeks with Dustin Galmore. And Galmore's contention, I was ready to go on the non-law violations. Galmore's contention was, well, the discovery encompasses these other instances or allegations that I need to get discovery for. In other words, it was all part of that one transaction, according to him, and the court granted him a continuance. So that's my.
Well, it's going to be, those things are always fact-based and every case is different, but when are we able to move forward on a hearing? What is called? We're waiting on what?
The DWI, yes.
A lab?
Yes.
Analysis, is that what it is?
Yes, yes, sir.
I hate to say this, but this is the third day in a row that I agree with Mr. Coleman completely.
What?
That we need to wait till we get the lab results back to show that this is a violation.
And
right now it's an allegation, but you can't prove that it's a violation.
And in the interest of judicial economy, Judge, what I plan on doing is with these cases that I've inherited, that are similarly situated, I just want to maybe get an agreed continuance so that we're not wasting the court's time and taking up,
Yeah. Well, yeah, we can be doing other things.
Yes. Yeah.
We're only, 15th highest crime rate in the state. And we don't have time to pass on much. Then next is Watson.
Same announcement. I did, however, file an actual continuance.
Yes, he filed on that and have no objection to that.
What are we? Once again, this one's filed in April, May, June, July, August, 4 months goes. That was on 4/6, so 4 months. What is it we're waiting on this?
That's the lab results, I believe, for the drugs. The new offense is possession of the drug, Your Honor.
There's a POCS that we're waiting on a lab. Same situation, Judge. It preceded me, someone else filed the MTRP. Going forward, we shouldn't have this problem going forward because I will not be filing the MTRP until we get that new case.
That's on Watson.
Apologize for this. We'll get it taken care of. We'll get it fixed.
Well, I'm just here to do things. That's okay. On Aaron Wiggins.
Yes, ma'am.
See what happened. 3 quarters of them. What way is that? I'm not saying it is so. Okay, Aaron Wiggins, what are you gonna do? If anything.
Today, we need to set it with the co-defendant. Co-defendant set it for September 28th. This is the non-shooter. We need to try to shoot first. We're trying to work them out same day. And they is the bond here. So that says trial. Well, that's the trial bond here. I've got a motion to reduce bond, but I don't think that was set for hearing.
No, that wasn't, not on yours. I'm talking about the co-defendant. I had it under his trial setting. It just was a note, but it's nothing to do. We need them at the same day.
The co-defendant says?
Co-defendant is Roderick Carter on September 28th for trial.
Before this also. John West is your lawyer, right?
Yes, sir.
Cameron Hernandez.
Yes, sir.
All right, and you've got two cases that are left here, 26 CR 53 and 26 CR 834. A theft in 26 CR 53. That's a state jail felony of theft. And then the no comment. The other offense, 26 CR 844, is also a state felony of theft. We've already resolved a
MJRP's right. These are just going to write with the.
So these are two new cases of state jail felonies. So what's going to be done today?
He's going to plead 2 years on each one of the jar.
Probably. Yes.
Oh, yeah. I know. And I don't know.
Yeah.
We got 2 years on to do this now.
MJRP's right.
What's this all right here?
So what? We're gonna. See that. Over $3,000 damage in the HEB and in the academy. We've got over $3,000 loss in that. So what's he doing about what are we doing about getting the people the $6,000 back? They're out of luck. And why would we run this concurrently if we're out of a loss? I mean, it's on his terms. It's convenient now. But he's not having to pay a loss tax.
We can put a judgment in the area, judgment in the.
How many of those have ever been satisfied?
Well, I don't know. I mean,
I've never heard of one.
Yeah, I mean, there may be some, but I don't think so.
No, that's the victims tell me why, or they run concurrently when he lost some money and he could have committed 20 and then pile them all together and he gets the benefit. He doesn't have to, he's not responsible for the loss like everybody else is supposed to be when they commit a crime like that. Besides, the prices went up because of you for everybody else. They're not the only victim. The people who shop at these stores, the Academy and the HEB, pilfering, the prices are increased and it's passed on to the honest people who shop because people like you make a mess and don't clean it up. You make a mess, you fix it. You're not fixing it by walking away with $6,000. You pocket it. And you don't have to pay it back. People don't find that fair. I don't either.
Yes.
Shame on it.
Yes, sir.
I'll think of you when I go into HEB. This makes, it's just, I'm used to this because I've done it a long time, but it makes people angry because they don't see the justice in that. And I can understand. I sympathize with them. I feel sorry for them having to pay more money because of you. And you're pilfering and not paying it back. But you're a thief. And you seem to continue to act that way and be that way. That's just dishonest, which is, I think, the worst thing anybody can be labeled. So there's just no respect and dishonesty. But people come along here nonetheless. There are not as many as I'd like, and they fix their problems. They make a mess, they pay it back, and they do better. That's what I want. That's what everybody wants. You, on the other hand, are just piling your messes on top of each other. You must seek to learn from previous issues, but you're not paying this back. Anyway, that's. What did he get on? He got 2 years on the other case?
On the motion to revoke probation, Judge. That was an agreement of a separate prosecutor.
Yeah, I know. I understand. What can we do? Can we fashion something so that the people get paid up, or at least he's out there and being held responsible for paying them back? Because he's not going to be if I tag it on to a judgment of confinement. You know that they never ever paid, but maybe I can put him on a regular probation for 5 years.
Personally, Judge, I don't want to do that. Not with these facts and circumstances. I understand why you're suggesting that, but that's not something.
And then he'll pay the people back. Maybe. If not, he's answerable to me.
You may have to do that as an unagreed plea, Judge, because with these circumstances, I'm not willing to agree to that.
I know you don't. You'll like it because you can pay. You've obviously got a reputation building.
I mean, like a payment thing or something. Did they have that whenever you are in there, like going on your books goes towards their restitution of it, or like?
We got 2 years in state jail on the other one.
2 years TDC.
We got 2 years TDC.
These are both state jails, and actually the 2 year state jail is probably going to end up being more time than the 2 years TDC. That's why I didn't have any.
2 years flat time on these two.
Yes, sir.
So run concurrent, right?
Yes, sir.
That was our agreement. Yeah. Or that's what we wanted. That's what we want to do. Just because you got 2 years to get the case resolved and moved and done. And because like, I think Mr. Ham believes, or he just said that even if we tack it on as a fee, he's never probably going to ever pay it. And normally I would be.
Well, he's not going to pay when he's in prison.
Right. I'd be sympathetic if not for the fact it's too, I hate to say it, the big companies that but
For me, it has nothing to do with the companies.
I don't care about the big.
It has to do with this man's conduct. He was on probation. He didn't learn his lesson there. He turns around and he commits two new offenses while he's on there. And I am really in no position to agree to an additional probation, because to me, it's just going to result in additional victims.
I think he wants to just give us time and be done.
I did my probation 6 times with them. That's 2%.
Just.
Deal felony.
But was it enhanced though by prior convictions or anything?
No.
Hold on.
He was given state jail. I looked at the judgment.
Let's take notes.
Yeah, let's find out. I looked a moment ago. It was 6 months on one and 2 years on the others, but looks like.
Well, these two, we're going to do 2 over 5. Is that what we're doing? And these two
with restitution
but do they run concurrently or consecutively with other cases?
They run these consecutively to the other cases, but concurrently together.
That's a mouthful. That's
I know.
Well, it's not. I'm looking at the plea agreement here on 53.
We may need to add.
And it says run. There's nothing checked. And then there's a cause number, but there's nothing checked concurrently or consecutive.
Oh, I didn't pick that part.
What we have are concurrent and consecutive,
right?
Within these 2 cases.
2 new ones are concurrent together, but both of these are consecutive to the other cases that he pled.
All right, let's not completed, and we need to put that down here.
The other cost number that he has been sentenced to is F22-39335, and it is a felony, state jail felony.
Okay, 22-39335.
Correct, Judge.
Where's that from?
That's the one that he was on probation when he committed these two offenses.
In this court?
Yes, sir.
Yes, I'll stand by. Okay. Run concurrently. I'm checking both concurrently and consecutively. So. This is okay. Okay, these two will run concurrently with each other.
Correct.
So I'm doing concurrent with 206. Say 3, 4. Consecutive. Consecutive with. What's the underlying felony that he?
22-39335. (22-39335).
So restitution in this case is equal to. In 53, that's right. 53.
The amount is $3,350.70.
Okay, say again, please.
$3,350.70.
And this is going to HE.
Correct.
All right, let's. Call 26 CR 53, and you are Cameron Austin Hernandez with your attorney, Mr. West, and the state's attorney. And again, does the defendant waive a formal reading of the indictment on the arraignment in these two additional state jail felony indictments? Can we proceed in summary?
Yes, please.
Beginning with 26 CR 53. In summary, sir, this indictment alleges that on or about November 25th, 2025, in Jefferson County, Texas, you committed the state jail felony of theft, food, cleaning supplies, and toiletries of a value of $2,500 or more, but less than $30,000 from HEB. Do you understand what you are charged with here?
Yes, sir.
If convicted of this offense, you are facing a state jail felony, which means you face confinement in the state jail for any term of not less than 180 days or more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in this case where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You will be placed on regular probation for 5 years. And you must pay restitution in this case in the amount of $3,350.70 to HEB. This sentence shall run concurrently with the proceeding state jail felony that you are going to be pleading guilty to here shortly in 26 CR 834, but it will run consecutively to cause number 22-39335, the theft. And that was a state jail felony as well. A state jail felony of theft for which you have been convicted of previously and sentenced to 2 years in the state jail on.
It's 2 years. Without reading the judgment, I'm not unsure if it's 2 years TDC or 2 years state jail.
It was 2 years TDC, Your Honor. I checked my notes earlier.
Okay, it was. I'm not. Okay, but we're saying this is, was it a state jail felony punished as though it was a third-degree felony by prior convictions, or was it a flat third-degree felony? It's going to be.
I'm hesitant to answer because I was not the attorney on the case, Judge. And I've been chasing, trying to find the paperwork without success.
Lacey, can you look into that? It's 22-39335. Well, our concern is, of course, is to make sure that victims are taken care of, and you're going to have, through this probation we're going to be putting you on, you're going to be required to pay these two victims back in this case, in these two cases that you're going to be convicted of and placed on probation. And again, for the record, this will be, this disposition in 26 CR 53 will run concurrently with the next case we're going to deal with, which is a state jail felony of theft in 26 CR 834. Those will run concurrently.
You just want the judgment?
Yes.
Yeah.
Thank you.
Sentenced to state jail, Judge.
I think it was 2 years.
Yeah.
Yes, sir.
Flash.
I think, and where the confusion is coming from, it looks like initially it was thought it could be TDC, and he was brought back in and resentenced to 2 years state jail.
Okay, so this will run consecutively to cause number 22-39335, for which you received a 2-year sentence.
Yes, sir.
Thereafter, that is completed. These two cases will move forward. You will be sentenced to 2 years in the state jail on each case. Those would be probated for 5 years, and those two cases would run concurrently with each other, but consecutively to 22-39335. Do you understand?
Yes, sir.
And also restitution is to be ordered in the amount of $3,350.70 to HEB. Is all of that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
Come on. We're having trouble with the stylus again.
Investigator summary.
No, something else.
Because I put it as I can use that, but if not, which one was to get some signatures with it.
So you understand the plan, Rich, sir?
Yes, sir.
In this cause number 2653, how do you plead to this state jail felony of theft? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you on this case, what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney or the contents are correct?
Yes, sir.
State's Exhibit 1 tendered into evidence. No objection. Without objection, it's admitted. In this case and the one following it, State's Exhibit 1 will be signed by you and the parties. And this states in each of these cases that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged with any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes in this case. Pre-sentence report is waived here.
Yes, please.
I'm going to follow the agreement in this case and find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty to this state jail felony of theft. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of theft of property. I'm following this agreement. You were hereby sentenced to confinement in the state jail for 2 years. That will be suspended. You will be placed on regular probation for 5 years. There will be terms and conditions of probation, normal and customary for this type of offense. But maybe most importantly, restitution is owed and shall be paid back to HEB, the victim in this case, in the amount of $3,350.70. This sentence shall run concurrently with the following case we're going to be dealing with, 26 CR 834, another theft from another merchant. But this case will run consecutive to the state jail felony conviction you earlier pleaded guilty to and have been sentenced to 2 years on 22-39335. Do you understand what has happened today, sir?
Yes, sir.
On this case?
Yes, sir.
All right. Anything else on this case? No?
No.
Good. Let's go to the following case, 26 CR 834. And again, does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about October 21st, 2025 in Jefferson County, Texas, you committed the state jail felony of theft involving an amount of $2,500 or more in goods, but less than $30,000 from Academy Sports and Outdoors. And this is a state jail felony. Do you understand what you were charged with?
Yes, sir.
If convicted of this, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand, sir?
Yes, sir.
An agreement's been reached in your case here where you would be sentenced to the state jail for 2 years. That would be suspended. You would be placed on regular probation for a period of 5 years. This sentence shall run concurrently with the previous case a few moments ago, you pleaded guilty to the state jail felony of theft in 2653, but it would run consecutively to cause number 22-39335, a sentence imposed July 24th of this year, which was a state jail felony of theft for which you were sentenced to 2 years in the state jail based upon a revocation of probation in that case. And in this case, restitution. In this 834 case, you will also be ordered to pay restitution in the amount of $3,003.27 to Academy. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, sir.
How do you plead to this indictment, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty in this case?
Because I'm guilty.
I show you what's marked as State's Exhibit 1 in this case. Did you sign that document, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. And similarly, as the previous case, you are, State's Exhibit 1 states that you are voluntarily, knowingly, and intelligently pleading guilty in this case. You are, you are mentally competent to do so. These pleas are freely and voluntarily made. You understand what you're charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true here. So help you God.
Yes.
State's Exhibit 1, part of the record for our purposes. Pre-sentence reports waived here.
Please, Your Honor.
Nothing further. I'm going to find that you are pleading guilty here voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in this cause number 26 CR 834 of this state jail felony of theft. I am following this agreement. You are hereby sentenced to confinement in the state jail for a term of 2 years. That confinement shall be suspended. You will be placed on the regular probation for 5 years. Restitution shall be ordered to Academy Sports in this case in the amount of $3,003.27. This sentence shall run concurrently with cause number 26 CR 53. The sentence of 2 years confinement, probated for 5 years, and restitution that you pleaded guilty to a few minutes ago in this case. But this sentence shall run consecutively to the conviction in cause number 22-39335 of credit or debit card abuse for which you were convicted in July of 2024, for which the court revoked your probation in July, on July 24th of this year, last month, and revoked your probation and sentenced you to 2 years in the state jail. All right. Do you understand what has happened in all of this, sir?
Yes.
Any questions?
No, sir.
All right. You've got some requirements here, but It's the right thing to do. And you've said you are willing to try to fix this mess and live honestly, pay these victims back, and do your best for you and your family. Is all of that true?
Yes, sir. I
Well-
do have a question on the restitution. If I were to pay the restitution off before the 5 years is up, is there any possible way of getting off of probation before?
I reward every day for good work during probation. You can always, your probation can be terminated in 1/3 of the time. 5 years, that's 1 2/3
Yes, sir. Understand.
of a year.
Yes,
So, but you got to earn it.
yes, sir.
And yeah, I enjoy doing that because it's success. It's people fixing mistakes and victims getting paid back and
Yes.
righting the wrong, fixing the mess. The planets get back in line because they have been tipped over because of the mess that's gone.
Yes, sir.
Yeah, in a sense of the words. We're going to also order you as a condition of these probations to complete a theft prevention class.
Yes, sir.
Hopefully make you a better person overall in the future. How many children do you have?
One, sir.
How old?
9-year-old.
What's the greatest gift you can give your child?
A big life.
Yeah. I'm thinking more about a good example because they're going to emulate their parent.
Yes, sir.
You have not been honest. You've set bad examples. You can fix this anytime.
Yes, sir.
And we're giving you a blueprint of success, but you got to walk the walk.
Yes.
Don't just talk a good talk. Do it.
Yes, sir.
See the probation officer.
Yes.
Good luck. Anything else?
Thank you.
We're in recess.
Thank you. Wait.